We're going to present a short overview of how a family law case moves through court. We will also mention the average time you can expect each stage to take. This is an introduction. Later videos in this series will explain terms and procedures in more detail, and you can find much more information on the Alaska Court System's Family Law Self-Help Center website. A divorce or custody case opens when one spouse or parent files a complaint or petition with the court. Complaint is the formal name for the document that states your intention to seek a divorce. The person filing the complaint will also have to serve the defendant, the other spouse or parent, with a copy of the document. The defendant then has 20 days to file an answer with the court. A status conference, when the judge sets the date for trial, is usually held 30 days after the answer is filed. Also, after the answer is filed in a divorce, the discovery stage for property disclosure begins. That is, each person will provide the other with a complete list of all financial and property holdings, as well as a list of debts. This is due 45 days after the answer is filed. In cases where there are children, the parents will begin to work on a parenting plan. During the time your case is in court, if you need an order from the judge, you will have to file a motion. Hearings on motions usually take place 45 to 60 days after the motion is filed. You will prepare for trial by assembling witnesses and documents. Throughout the trial preparation period, you can try to settle your case on your own or through mediation. The judge may schedule pretrial conferences during this period. If a settlement takes place, there will be no trial. The judge will schedule a hearing to put the settlement on record and the case will be over. If you cannot reach a settlement, the trial will take place approximately 6 to 9 months after the complaint was filed. The judge will make the decisions at trial. He or she will issue a decree or judgment. The judge may tell one of the sides to prepare and file the final papers for the case based on his decisions. If the other side disagrees with how the final papers are prepared, he or she can file an objection and attach a new set. When the judge accepts and signs the final papers, the case is finished. If the defendant does not file an answer within 20 days after the complaint is filed, the plaintiff will file a default application with a proposed judgment. The court clerk sends the plaintiff and defendant a signed entry of the default with instructions about a hearing. The plaintiff must attend the default hearing. If the defendant chooses not to appear, the hearing will still take place. Both the plaintiff and defendant will receive the decree or judgment in the mail 7 to 10 days after the hearing. The case is finished. For more detailed information, you can visit the Family Law Self-Help Center website.